Yes, Mr. Malika, you may proceed.
Thank you, Chair. Mr. Ephraim, we were at page 7, paragraph 31 of your statement, and you had set out the position expressed by Mr. Malefe. And in paragraph 32, you talk about how the turn of events arising from that position was unfortunate, correct?
Correct.
And why do you think that that was unfortunate?
Well, we've been down a long period of negotiation with Eskom, and there's a significant amount of history regarding the negotiation.
I'm sorry. There seems to be some sound of people speaking that comes from my right. I don't know whether it's somebody's cell phone or what. Okay, let's proceed. Hopefully.
That's not mine.
Let's proceed. Hopefully it won't come back.
Chair, does it disturb you? I mean, can you hear us?
I can hear you, but it was interfering.
Okay.
But it's quiet now.
Okay. Thank you, Chair.
Yeah, thank you.
You said that you have been down the road on long process of negotiations, and
we'd got to the point where we felt that we had reached some sort of conclusion on the Optimum saga, and only to be stonewalled at that point in time. We further felt it appropriate to write a letter to Mr. Molefe. I'd like to refer you, please.
yeah, the letter appears at page 173.
173.
Yes. And you addressed it to Mr. Malefe and Mr. Vusimboweni, acting head of primary energy. It was on the 22nd of May 2015, and we know that this date of 22nd of May is quite popular in your dealings with Eskom. We have dealt with the 22nd of May 2014.
Right.
Yes.
Only by coincidence.
Only by coincidence.
Yes.
All right. Just take us through the important aspects of this letter.
Thank you. In the first few clauses of the letter on 173, we just deal with the background, the negotiation, progress had been made. We understand the situation that Eskom is also in a difficult financial position. We speak about efficient cost plus a fair return. We speak about various different things that had arisen during the negotiation. And then on page 174, second clause, they unfortunately not numbered,
Yes.
Deputy Chief Justice, but it's the second paragraph.
Yes.
Eskom's negotiating team advised OCM that the terms of the deal were subject to the approval by the Executive Procurement Committee and then the Eskom Board Procurement Subcommittee on the 25th of March 2015. Eskom was later advised that the Executive Procurement Committee had approved the terms of the deal. And it just talks about the fact that it needs
I had, like you said, Eskom, where it should be OCM, or did I not hear you properly? It's, according to the letter, it's OCM that was advised.
OCM, yes, third line, OCM was advised that the Executive Procurement Committee had approved the terms of the deal. And,
Yes.
then I'd like to read from the next paragraph to the next clause onwards, this outcome, middle of the page. This outcome is obviously very damaging for OCM because it was on the back of such potential deal that OCM has been able to persuade its shareholders to continue advancing funds to the mine in order to enable it to continue operating. As previously indicated, OCM has exhausted all of its available banking facilities in the amount of 2.5 billion and requires approximately 100 million rand per month in order to continue operating. The shareholders of OCM have advanced approximately 1 billion rand to OCM since October 2014. If I may continue.
Yes.
In the circumstances, the directors of OCM feel compelled to write to Eskom regarding the position in which they find themselves. As things stand, OCM does not have sufficient funds to continue operating without shareholder support. As indicated above, the shareholders of OCM committed to fund OCM on the basis that the negotiations with Eskom were ongoing and that a deal would be concluded with Eskom which would in some way improve the unsustainable financial position of OCM. The shareholders of OCM have, however, indicated that if no progress is made in the negotiations with Eskom by the end of May 2015, the shareholders will have to reconsider their support for OCM and may withdraw all such funding. If this occurs, the directors of OCM will, in accordance with their legal duties, have no choice but to place OCM in business rescue or liquidation, which would be very harmful for all stakeholders. In the next paragraph, reading from the second last line of the page, it is clear that the only possible method of rescuing OCM would be through an amendment to the Hendrina supply agreement, because the agreement is so onerous that it precludes any other alternative solution. And then in the final paragraph, I'm now reading almost from the third line down, OCM does not want Eskom to feel that it is negotiating under duress, but the negotiations with Eskom have been ongoing for 2 years and the directors have legal duties which they cannot ignore. It is with this in mind that we as the directors of OCM implore Eskom to reconsider its position and to provide confirmation that Eskom is willing to conclude a deal with OCM.
Yes. Are you aware whether Mr. Molefe received this letter?
Yes, he did.
What was his response? If any, of course.
Initially, he did not respond. Paragraph 34 of page 8 of my statement. So, up until the 11th of June, Eskom did not respond.
And what happened on the 11th of June?
We arranged a meeting.
Well, I'm sorry, before the end of June, the last sentence that you were reading, you didn't read the whole of it, obviously, because you understood that what you had read had made the point, but I see that when one looks at the balance of that sentence, it does make the point that you or the directors of OCM were not rigid in terms of saying Eskom must go ahead or confirm the agreement as it was that had been that was supposed to have been approved, but you say there can be another basis as long as it was meaningful that could be looked at.
That is correct, Deputy Chief Justice.
So you were not rigid to say
we were not.
That or nothing else. You were prepared to look at any other meaningful option.
On the understanding that perhaps the new board felt that this was not appropriate, maybe there was something else that could have been done, that could have been more appropriate at the time.
Yes, okay, thank you.
Thank you, Chair. Can I take you back to the events of 11 June 2015?
Yes.
Which you begin to describe from paragraph 34.
Yes, so we had a meeting, it was myself, it was Glencoe's Group CEO, Mr. Ivan Glazenberg, and Mr. Molefe, who was accompanied by a number of representatives of Eskom. This meeting was held at Eskom. And again, we went to try and discuss and see if there was a way forward in terms of what we could do. Remember, we were now on the 11th of June, so we had already passed the deadline of the 31st of May, which in our minds was going to be the latest date for continuing to fund. And the 11th of June, we were still continuing to fund the mine, but we thought, let's have another meeting in which perhaps we could pave the way for either new negotiation or anything of the sort. But once again, it was the same response that we had always got, was that Eskom is not willing to negotiate, and the contract is in full force, and we must continue to perform the contract.
Before your first meeting with Mr. Molefe, the arrangement had been that the agreement or proposed agreement was going to be tabled or tabled before the board or referred to the board for their consideration. Is that correct?
Correct.
But then you had a meeting with Mr. Molefe and you had what he articulated, what he said was Eskom's position.
Correct.
Now, did you ever get to know whether the board had discussed the agreement before it was referred to him, or whether the board discussed it at any stage after, or was it just that he articulated Eskom's position and that was that?
My understanding of the events was that at the board meeting, it was discussed that Mr. Molefe would take charge of the discussions with Optimum at that point.
Oh, okay. Thank you.
Thank you, Chair. You have now referred to two meetings you have held with Mr. Molefe. The first being your one-to-one meeting with him on the 18th of May, and the next being your meeting with the Glencoe Group CEO on the 11th of June. And you were trying to impress upon him the importance of the fourth addendum.
That's correct.
My sense of what you recollect as his response was simply to say, look, Eskom wants you to fulfill your obligations under the CSA.
That is correct.
Beyond that stance, did he say to you why he did not consider it to be in the interest of Eskom to consider and, if necessary, negotiate further terms of the fourth addendum?
Yes. In very brief terms, he said that Eskom can't renegotiate this contract.
No, but understand, that's an expression of a negotiating position. What I want to understand is, what were the reasons? Why was he not prepared to engage on the substance of what was before him under the fourth addendum?
I don't know. I can't speculate.
Did you ask him?
We did.
And what did he say?
He simply said Eskom can't renegotiate this contract.
And you obviously had articulated to him your own motivation of why you believed that that agreement was good for both Eskom and yourselves.
Yes.
You had motivated that.
Yes, of course. And we
Yeah.
would have made reference to the letter of 22 May, which clearly articulates our
Yes.
position.
And did he dispute any of the reasons that you were advancing that in your view showed why this agreement would be good for both Eskom and yourselves?
No,
Yes.
no.
You know, we're asking you these questions for your assistance because Eskom is a public entity. Its officials exercise public power for the benefit of public institutions. It's not private power. And there has to be good reasons why those powers are not exercised in the interests of Eskom. From what you have told us, senior managers were satisfied that the fourth addendum is in the interest of Eskom. You're telling us that the incoming acting CEO simply put negotiating stance without giving reasons, other than to express the view that Eskom is not prepared to negotiate the CSA.
That's correct.
Was that not surprising for you?
Of course it was surprising.
Did you tell him that that was surprising for you?
We did. It was a stonewall negotiation, Deputy Chief Justice. It wasn't a discussion. It was a position.
Hopefully when he comes, we'll ask him why that was the case.
And this was his attitude, or was this his attitude not just at the meeting that he had with you, the two of you only, but also at the meeting that he and other people from Eskom had with you on the 11th of June?
Identical. It was the same theme all the way along. Eskom's stance was they're not negotiating this contract.
You might or might not be able to assist here. With regard to the meeting that you had with him, just the two of you, how long do you recall that meeting took? How long did it take?
Not more than 10 minutes.
Yes, and the second meeting on the 11th of June, do you recall about how long
Maybe
it took?
45 minutes.
Yes. Okay, thank you.
All right, we have dealt with paragraph 35. And in paragraph 36, I'm at page 9 of your statement. You say, finally there arrived a formal response from Eskom, which is CE7 of your statement. Chair, you'll find that at page 176. And I'd like to take you to the terms of that response. What is the date?
176, you said?
Yes.
Okay, thank you.
Thank you, Chair.
Yes.
Are you there, Mr. Ephraim?
I am.
What is the date of that response?
10th of June.
Who is the author of that response?
Mr. Molefe.
And can you take us through the essence of that response? If it's necessary, you can read it.
Sure. It's directed to me, Optimum Coleman. It was only received on the 22nd of June. So it was received only after we'd had the meeting of the 11th of June. Acknowledgement of receipt, Hendrina Coal Supply Agreement. We acknowledge receipt of your letter dated 22 May and the issues you raise in it. However, considering Eskom's current financial position, which is public knowledge, we unfortunately cannot afford to reset the contract price to that proposed by Optimum Coal Mine. It remains a priority for Eskom to ensure the security of coal supply to Hendrina Power Station, not only for the remainder of the current coal supply agreement, but also for the remaining life of the Hendrina Power Station. Therefore, it remains critical to all stakeholders that Optimum Coal Mine continues to deliver coal as per the current contract. Eskom, to the extent that the cooperation agreement still regulates, the settlement process hereby notifies Optimum Coal Mine in terms of clause 5.6 of the agreement that it no longer wishes to participate in the settlement process. Eskom accordingly hereby terminates the settlement process and confirms that the provisions of the CSA and addenda are forthwith applicable in respect of inter alia coal qualities, quantity requirements of the Hendrina Power Station. However, the negotiation teams should continue to negotiate a new CSA for after 2018 in respect of the remaining life of Hendrina Power Station.
Two things arising from that response for your comment. It seems to me that the termination of the cooperation agreement re-triggered the arbitration process, which was suspended.
That is correct. Only subsequently to this letter.
Yes. It also seems to me that the Eskom position was that there would be negotiations and the parties can begin to negotiate a new CSA, but only after the end of the lifespan of the one that was subsisting at the time, which was going to end sometime in December 2018.
That is correct.
What was your response after you received this letter from Mr. Molefe? Because it raises questions of lack of affordability. Do you see that?
Lack of?
Affordability, the price. Eskom says that it doesn't have the financial resources.
Yes. So I think the answer to your question, if I may, is encapsulated well in paragraph 37, page 9.
Paragraph 37 of your statement.
That's correct.
Yes.
While Glencoe and OCM understood that Mr. Molefe was entitled to his position and how that position might benefit Eskom in the very short term, Eskom would continue to receive coal at low prices, we felt that Mr. Molefi's position did not necessarily appreciate the risk that Eskom faced after 2018, where they would have no security of coal supply from the mine, which was located very close to Hendrina, and therefore would be left in a very weak negotiating position. Not to mention the fact that business rescue and liquidation were possibilities that had been raised in the letter of 22 May.
Yes. Can I run ahead of myself and ask you this? You indicated that Esco may well have faced a risk after the termination of this CSA in December 2018. We are now almost, 3 months, 4 months after the contemplated end of the lifespan of this CSA. Do you know what is happening to that mine, to Optimum coal mine, as we speak today?
My understanding is that there's no coal being supplied from Optimum to Hendrina Power Station. Zero.
Do you know why?
My understanding is that the mine is in business rescue and does not have the funds to operate.
Do you know where Hendrina gets its coal supply?
I'm not aware. They can only be road transporting it from other mines.
Subsequent to your meeting with Mr. Molefe, the two of you alone, and subsequent to the meeting of 11 June, did you ever have occasion to interact with some of the PED management personalities who had been involved in the proposed agreement that you knew supported it? Did you ever have a chance to interact with them and ask them, what has changed now? Why is Eskom so much against this agreement? And if you did, what did they say to you?
We did. This was informally, of course, Deputy Chief Justice.
Yes.
They were as perplexed as we were.
Mm.
But then a lot of them became or were suspended.
Mm.
I don't think any of them are still working at Eskom to this day.
Yes. Thank you.
Thank you, Chair. You wanted to respond to the question that I raised with you concerning Mr. Molefe's response about the financial precarious position of Eskom. And you said that I will find the answer in paragraph 38 of your statement.
37. You said
37.
Yeah,
I'm
37.
sorry. Yes, I'm sorry. Can you just take us through what the answer is all about?
So if we go back to the background once again, and I think we've explored this extensively. Hendrina Power Station is wholly reliant on Optimum coal mine for a number of reasons. Logistical, specifications, convenience. The power station was designed for this coal. So when we say in the middle of that paragraph that did not appreciate the risk that Eskom faced after 2018, we knew that it would be a huge problem if the mine did not continue and the mine could not continue after 2018 or when a contract could not be negotiated. It was not unusual to start negotiations or to discuss extensions of contract years in advance. Eskom does that all the time. It's never and never should be a just-in-time situation for Eskom. Primary Energy should be well aware of the resources, the capability of the mine, what it's capable of producing after the end of the contract, and they should be in a position to start negotiating well in advance so that you don't negotiate it on the 31st of December 2018 when the coal stops the very next day. It's absolutely critical to the power station.
You use a very interesting phrase, just in time.
Should never be just in time. Purchasing for coal should never be just in time. There's no excuse for that.
Okay, just in time is you produce and supply it as and when it's needed. You don't carry available stock. I'd like to raise something, Chair, which arises from the evidence of then Minister Ramatlodi, who you heard, because in the context of what Mr. Ephraim is telling us now,
Yes.
Minister Ramatlodi said something about Mr. Molefe, and then
Yes.
the chairperson of Esco, Dr. Ngubane. I wonder whether you recall that evidence.
Well, I certainly recall that he mentioned them. He mentioned that meeting which he had with the two of them.
Yes.
Is that what you want to raise?
And ask for the witness comment and
Yeah.
ask him whether or not he can corroborate or say something about that version.
Yeah.
And Chair, just to make sure that I do not misquote or mischaracterize his
Yes.
version, I'm going to read from paragraph 21 of, well, maybe let me start at paragraph 19 of his statement.
That is Mr. Ramatlodi's statement.
Yes.
Yeah, okay.
He says the following, you were not here when he testified, but the chairperson receives evidence from different persons, and one of them was Minister Ramatlodi. I read from paragraph 19. The next event had to do with Mr. Brian Molefe, who had suspended the Optimum contract to supply Hendrina Station with coal. 20, the reason as provided by Mr. Molefe, then Eskom Chief Executive Officer, was that Eskom was owed 2 billion rand by Glencoe. Mr. Molefe was refusing to meet with Glencoe to resolve the issue. I had a meeting with Mr. Molefe to persuade him to meet with Glencoe to resolve the matter. 21. The same evening, Mr. Molefe called me to say Dr. Baldwin Ben Gubane, his chairperson, wanted to meet with me. We then met in the office in the presence of some officials. At that meeting, Dr. Ngubane basically instructed me to shut down all Glencoe-owned mines. He said that he needed a decision to be made in the meeting so that he could report to the president, who was leaving on a foreign mission on that day. I informed him that I was unable to take a decision like that without due process being followed, as these processes would enable me to make an informed decision. For purposes of your comment, do you know Mr. Ramatlodi?
Yes, I do.
Have you had any interaction with him in his capacity as the Minister of Minerals and Energy?
Yes, I did.
What role, if any, did he play in relation to the problem that Glencoe through Optimum coal mine was experiencing?
We had an issue when the process to close down the open cast mine, we were retrenching a number of people, and the concern from the DMR wanted to make sure that we were doing everything by the book, and we subsequently proved to them that we were. That was the brief encounter that I think we had with Minister Ramatlodi.
Do you know anything about the fact that he was approached by the persons he mentioned with a view to shut down Glencoe's operations?
No. No.
It might be important, Mr. Muleka, if that statement does reveal, to place a date to that meeting and see how it connects. It may connect with the dates of the meetings that Mr. Molefe had with the witness and subsequently with other people on the 11th of June.
Chair, I'm trying to look for a date.
But if you can't say it now, maybe it can be looked at for later, just to see in relation to these events how far that date is.
Yes, I'll look at it, but from the paragraphs that I've read and those preceding them, I could not pick up a date.
Yeah.
Unless in the course of his oral testimony he was asked and he put down the date.
Yeah, okay. No,
But
that's
I'll
fine.
look at it. All that I wanted to find out from Mr. Ephraim at this stage is whether or not there was a talk of shutting down Glencoe's operations in the country. And your evidence is that you don't know.
We were not aware of that.
No one told you about this.
No.
Okay.
Do you know, Mr. Malega, as of now, because Mr. Ramatlodi's statement would have been served in terms of Rule 3.3 or the relevant portions
Yes.
on Mr. Brian Molefe as well as on
Dr.
Dr.
Ngubane.
Ngubane
Yes.
a long time ago.
Yes.
Do you know whether they have responded to say they want to?
Not as far as I'm
process
aware,
them,
but I know that Dr. Ngubane was legally represented by one of our colleagues who came to make an appearance
Yes.
when I think it was Ms. Hogan who
Yes.
testified.
Yes.
I'm not too sure about the testimony of Mr.
Mr. Ramatlodi.
Ramatlodi, but I can confirm that
Yeah.
and come back to you about it.
Okay, no, that's fine.
Want to make a note?
Yes,
Chair,
you may
I have
proceed.
already confirmed that the arbitration processes relating to the hardship clause resumed, and you confirm, Mr. Ephraim, that a hearing was scheduled for those proceedings for the 16th to the 27th of May 2016. You do so in paragraph 39, correct?
Correct.
And then you start a new topic. You call it the first Oak Bay offer from paragraph 40. You see that?
Yes.
Do you want to deal with it quite quickly? One thing that strikes me is you say that the offer was received from KPMG, from one of its clients, whom it described as anonymous. You see that?
Yes, I do.
Do you know why KPMG would approach you?
I had no idea why they would do it anonymously. They approached us, and then we responded saying that we're not dealing with anyone anonymous, and that's when they advised that the interested offeror was Oak Bay.
We'll go to the offer. But you say subsequently when you told them that you don't deal with anonymous offerors, you then were told who their client was. First thing first, do you know how KPMG came to make this unsolicited offer for the acquisition of Optimum coal mine?
No,
You did not ask them.
I don't recall. Optimum was very much in the press and the media at that point. There was a lot of stuff going on in terms of media, so perhaps they were opportunistic.
So were some of the challenges that Optimum was facing public knowledge?
Very much so.
Okay.
Can I take you to the offer, which is at page 180?
What's the page number again?
180.
Thank you.
It is dated 1 July 2015, and it is addressed to Sean Blankfield at his email address. Do you see that?
Yes.
Just for our own orientation, who is Mr. Blankfield?
So Mr. Blankfield was the head of our corporate finance at Glencoe here in Johannesburg.
Yes. And you see that paragraph 1, unnumbered, that is, on page 180. That's the first paragraph. Refers to commercially sensitive information relating to their client's operation. Do you see that?
Yes, I do.
When ultimately you got to know who the client was and began negotiations with them, did you ask them to explain what was the commercial sensitive nature of their client's operation?
I really don't recall.
And then in paragraph 1, now numbered, background to our client, you see that they refer to diverse operations of their client, and they say that it's a black empowered company, both in terms of the mining charter and in terms of Eskom's procurement requirements, and is already a successful supplier of coal to Eskom, and it is familiar with Optimum Coal's operations. Do you see that?
Yes.
So that it seems to me when I read this that whoever the client was at that time was quite aware and had some knowledge of your operations. Do you see that?
Yes.
So whoever was making the offer at that point in time did so from some level of understanding what the operations were. What I want to ask you is this. How would a third party, such as the client of KPMG, have acquired knowledge of the operation of your entity? Was this a matter that was publicly available for interested parties?
Up until 2013 sometime, Optimum was a listed company. So there was information up until 2013. I'm not sure of the exact date of delisting. But between 2013 and this point, they would not have had detailed information on the mine at all.
Yes.
It would have been reported through the Glencoe structures, but it would not have, there would not have been a lot of detail around the mine.
But it's fair to assume that it is 2015, and from open source material you'll gain some sense of what the operations of Optimum are.
You gain a very general background of Optimum, sure.
Yes. Then on page 181, there is an indication of what is the amount of the non-binding offer which was proposed at that point in time. Do you see that?
Yes.
How much was it?
2 billion rand.
Are you able to explain to us how that land would have proposed that non-binding offer in that amount
I have no
at
idea.
that point in time?
I have no idea.
And then there is a next part that I'd like to raise with you because it's going to become important as we talk about the financing of the last offer of Tegeta and Oak Bay. At that point in time, there was a financing structure that was proposed in paragraph 4. Do you see that? On
Yes.
page 181. Can you just deal with it for our benefit?
Sure. Our client has held discussions with its bankers regarding their capacity to fund the acquisition of Optimum Coal. Based on their existing business operations and assets, i.e. without recourse to the assets of Optimum Coal, they have received written letters of support for the required funding, which together with cash resources would allow them to fund the proposed purchase price of 2 billion without recourse to the assets of Optimum Coal.
Yes. I mean, Mr. Ephraim, subject to questions of anonymity of a client, this appears to be a serious offer on the face of it. And someone who comes to you and says, don't worry about funding, I have finances and I have funding to support the deal, seems to suggest that it's someone who is serious in making the offer.
Perhaps serious in making the offer, but we didn't take it very seriously at that point.
Why did you not take it seriously?
Because it lacked detail and understanding of Optimum, and of course it's an opening gambit, it's an opening letter. It's
Yes.
not a serious document that one can really consider at that point in time.
All right.
We were far more preoccupied with trying to resolve our issues with Eskom than worry about this offer.
when you say you didn't regard it as a serious offer, does that mean, or is that separate from whether it was genuine or not? Was that based on maybe the price that they were offering the offer, or it was just other details in the letter that they had included in the letter that made you think it was not a serious offer?
Allow me to elaborate, Deputy Chief Justice.
Yes.
This kind of letter that is subject to a due diligence cannot be taken as anything serious. It just, all it is an indication to commence discussions.
Yes.
That's why I say, I'm not saying that they weren't necessarily serious buyers, but in terms of the way in which the letter was structured and in the way we read into it, anything subject to a due diligence means it can change at any opportunity, at any moment.
Yes.
And approvals and all the necessary things.
And maybe the anonymity of the offerer?
That too.
Yeah, okay.
That too.
Okay.
Yeah, but the cover was revealed later. I mean,
yes, even once the cover was revealed, it still had the same terms. It still had approvals of their senior management. They had approvals of their senior management. There is a significant amount of clauses in this offer document that says that it's still subject to various stages of negotiations.
So there were still too many variables that could happen.
There were too many variables in order to take this seriously.
Okay.
Not at that point. It's a big acquisition. It has to go down a long road in terms of negotiation.
Yes, but it was an intent.
It was
of
clearly
a first
an intention.
step.
It was absolutely clearly an intention to transact.
Yes. Then you move away from that offer and begin to raise a totally different topic in paragraph 41. And it's again the position of SEO OCM around July 2015. Do you see that in paragraph
Yes.
41? And then you say in paragraph 42 that out of the blue, you received a letter from Cliff Decker Hofmeyer, representing Eskom, demanding payment of penalties in the order of 2 billion rand. Do you see that?
Yes, I do.
I've tried to connect what was happening to you in relation to the first Ogbe offer and what happened as a result of the letter you received from Cliff Decker on the 16th of July 2015, asserting payment of penalty.
I can't help you join those dots. I can only give you the objective facts of what I have.
Yes, I understand. It's surprising for me, and I'd like your comment on it, that there is some measure of commonality between the Ogbe offer of 2 billion rand and the extent of the penalties which were immediately asserted by Eskom.
At that point in time, I'd have to say no. I can only comment for that point in time.
You did not see matters that way at that point in time?
No, we did not.
Can I ask you, Chair, to go to the letter and ask Mr. Ephraim to comment on its attachment?
Are you referring to CE10, page 184?
Yes.
Can I take you through this?
I will do so. I'll ask you to do so. And I would like you to go to the attached schedule at page 187? That's the spreadsheet which was attached by Cliff Decker Hofmeyer as a calculation of the penalties that came to 2.1 odd billion rand, correct?
Correct.
I take it that you received this letter.
Yes.
I take it that you applied to your mind to the question of the penalties and how they were calculated.
Yes.
What was your view of those penalties after you applied your mind to them?
Well, the penalties were broken down into different parts.
Yes.
In terms of this spreadsheet, there was sizing, there was calorific value penalties, there were ash penalties. Basically, in summary, what the spreadsheet did and what the letter from Cliff Decker Hofmeyer purported to say was that all the coal that had been supplied by Optimum coal mines from the period 187, right in the top left, it's very small, all the coal that had been supplied from March 2012.
Yes.
Deputy Chief Justice, are we together?
Yeah.
Yes,
All
I'm
the
looking.
way through to May 2015 had been rejected. In other words, the value of the penalties that were implied by the letter and calculated to get to the 2.1 represented the full value of the coal that had been supplied for the period 2012 to 2015. So essentially, they wanted a refund of all the money that they'd paid to Optimum for the supply of the coal, and the total coal was around 16.5 million tons for that period. Substantial amount of coal.
My question is slightly different, but go ahead.
So, the important part, we saw this as completely ridiculous in that, firstly, we'd commenced the negotiation process to speak about the sizing, which had been on hold during the cooperation agreement. And that was the triggering of 3.4.3 of the addendum, if you recall. That was the sizing renegotiation. And also we had numerous discussions regarding the interpretation and the calculation for the ash and CV penalty. Eskom took it as if that was the final penalty and levied this 2.1 billion penalty on the mine at that point. That wasn't our biggest problem. Our biggest problem was far more severe. We knew that we could defend this because we knew what our rights were. The bigger problem was the way in which the penalties were paid was via a set-off process. And the set-off process going forward would indicate that if Eskom still took the stance of imposing these penalties on the mine, then the mine would not be paid for any coal that would subsequently be delivered post this letter. And it was proven at the very next month I'm going to jump just a little bit because I think it does have relevance.
Yes.
To paragraph 47, page 12 of the statement.
Yes.
It says that at the end in the second line down, at the end of July 2015, Eskom withheld payment for no justifiable reason in an amount of approximately 58 million for coal which OCM had delivered that month. This was despite, I'm reading, a letter addressed to the BRPs dated 14 August 2015, in which Eskom confirmed that it would make payment. Payment was then refused again at the end of August 2015 for coal delivered that month, this time for 34 million. I'm only jumping to that, we're going to get there, but I'm only jumping to that to prove the effect of the letter that was sent to us from Cliff Decker Hofmeyer on the 16th of July, the effect of the way in which we read that letter. And that is articulated clearly in paragraph 43 of page 11 of my statement, which says the following. The manner in which the penalty provisions of the CSA worked meant that penalties could potentially be set off against the price at which coal was supplied to Eskom by OCM, with the effect that OCM could be required to supply coal at R1 a tonne. The alleged penalties were therefore a matter of serious concern to OCM and made business rescue proceedings very likely.
So, is the position that, at least as you understand the Eskom's position in terms of the agreement, was the position that if they maintained that there were penalties that they had a right to impose, they could just help themselves to whatever money you were supposed to be paid for coal that you had supplied, or there was to be some other forum which would determine first whether they were entitled to that penalty and how much it was?
No, the first part of your statement is correct.
Yeah.
That they
Yes.
indicated, well, that the way in which we read the letter,
Yes.
and together with the fact that July and August of 2015 were not paid for,
Yes.
it was clear that that was the intention,
Yeah.
that there was coal would need to be supplied under the CSA, but it would not be paid for if the interpretation of the agreement was as per their understanding.
But you had a different view as to how that should happen if there are penalties.
We had a completely different view. We had taken
Yes.
advice at the time
Yes.
that the way in which they were calculating it was incorrect.
Okay, all right. Thank you.
I think your last statement gives an answer to what I wanted to establish. That you applied yourself to the calculation of the penalties. I'm just talking about the question of the calculation. I'm not talking about the rights or the obligations arising from it. All I wanted to ask from you is that when you look at that schedule, you must have adopted a position. And I wanted to establish from you, what was your position in relation to the calculation of those penalties?
Our position was that the calculation was wrong.
Yes. Were you able at that point in time, now that you had concluded the calculation was wrong, what was the quantum of the penalties asserted, which was wrong? We know the full amount asserted is 2 billion rand. Had you come to the conclusion that it was wrong because they were claiming so much and they cannot justify so much?
It's not simple to answer that question.
And if you can't, you can't.
It's not simple to answer that question. There's too many variables, if I may, if I can not answer that, because there are too many variables. There's sizing, there's CV, there's ash, and it would become very complicated for this commission.
And what you regarded as the wrong calculation or method of calculation led them, as far as you were concerned, to a wrong total.
That's correct.
Okay.
But I'm going to reiterate, if I may,
Yes,
that
yes.
we always knew we could defend that.
Yes, yes.
We always knew in the back of our mind that if that, because that would trigger arbitration.
Yeah,
What we couldn't deal with
yeah.
was the fact that we had to deliver coal going forward, and Eskom would apply a set-off mechanism. So while you are in arbitration to discuss the very penalties,
Yes.
no funds would be received by the mine. It would not be possible for the mine to survive on that basis.
Yes. Yes.
We had hit the saturation point, I think,
Well,
at
Did
that
you,
time.
was your position that you were not liable for any penalties at all, or was your position that you were liable for some penalties, but not as much as Eskom was saying you were liable for?
There may have been an amount that that the mine was liable for
Yes.
would have to have been determined through an arbitration process.
Yes, okay.
Yes. Do you know whether that claim of penalty became a subject matter of arbitration? Remember, you had already told us by now, when you received this letter from CDH,
Yes.
that the parties had agreed to reschedule the arbitration proceedings for a hearing
Yes,
in May 2015. I think you say so in paragraph 39, if I
Yes.
may take you backward.
Yes.
I assume that that would have been a date which was agreed with the lawyers of the parties concerned.
That's correct. But the penalties would not have been discussed. That would have been an initial hearing that would have taken place at that point in time.
Yes,
So the penalties discussion would not have come about at that point.
yes.
Recall that that nothing at that point had been discussed with respect to the penalties.
What I want to understand is that once Eskom assessed these penalties,
Yes,
there would be a new round of arbitration to determine that question.
that's correct.
Yes.
Separate to the arbitration that was referred to in point
Yes.
39.
Yes. Mr. Ephraim, I'm going to get to a different topic. And that is the topic you described as the first Oak Bay offer 2 in brackets. I would come back to the question that you raised in paragraph 43. We'll come back to it, I can assure you. But I'd like to deal with that issue beginning at paragraph 44. You talk about the execution of what you call, and I read from the last sentence of paragraph 44, a confidentiality and non-binding disclosure agreement, which you annex as CE 11. Do you see that?
Yes.
I'm not too sure how we should deal with it now. You describe it as a confidentiality non-disclosure agreement. These proceedings are open.
Yes, it's. I think it's very simple to deal with it. And what happened is if you look at the sequence of events,
Yes.
We received the 16th of July letter. We were processing the implications of the letter. While that happened, we were seriously considering placing the mine in business rescue at that point. And all that happened on the 25th of July was that we knew that the business rescue practitioners would in some way look to entertain any potential suitors at that point, because that's what business rescue does. And that's why a confidentiality and non-disclosure agreement was signed with respect to certain information that would be given to Oak Bay for their going forward in their discussions. It was the very next week, on the 31st of July 2015, I'm reading from paragraph 45 on page 11 at the bottom. On the 31st of July 2015, the board of directors of OCH and OCM resolved to commence voluntary business rescue proceedings in respect of each of OCM and OCH. And if I may continue.
Yes.
The decision to place the business under business rescue was driven by the fact that in addition to OCM being required to sell all coal produced below cost, it now had to contend with the alleged 2 billion rand penalty and the prospect of supplying coal to Eskom for effectively 1 rand per tonne. Yes. The 1 rand per tonne actually comes originally from the CSA that's the absolute minimum that must be paid by Eskom in the event of a penalty scenario.
Yes. Thank you for that context. But what I wanted to understand, and without revealing confidential information, it seems to me that at that point in time you had begun to disclose information to Oak Bay with a view to consider its offer, the first offer, correct?
Correct.
Yes. But within that period or shortly thereafter, you had executed that NDA. You realized that Optimum coal mine was now facing serious financial difficulties, arising from the fact that it was supplying coal to Eskom below cost, and it had to contend with the potential of the penalties.
That is correct.
And you decided to initiate voluntary business rescue processes.
Correct.
And that is easy to achieve. You simply file a special resolution.
That is correct.
And the proceedings commence.
Correct.
Yes. What I want to understand is, did that mean at that point in time when you put Optimum coal mine into business rescue, mean that you are closing the door for the negotiations which were proceeding with Oak Bay, or you left it up to the business rescue practitioners to take the matter further with Oak Bay?
We left it up to the business rescue practitioners.
So the offer was still on the table?
Correct.
Yes, thank you for that. Then you say in paragraph 47 that the relationship between Eskom and Optimum Coal continued further to deteriorate, reflecting on paragraph 47 of your statement.
Yes.
And there you say that Optimum Coal continued to supply its coal to Eskom for July and August and invoiced two separate amounts, correct?
Correct.
And that is an issue which I had skipped because you had raised it in paragraph 43. I'm not going to take you back to 43. I'm merely cross-referencing that paragraph to make it clear that I had not forgotten it. And it's in this context that I begin to raise the concern you raised in paragraph 43. Do you know why Eskom withheld?
No.
Did you raise it with them?
We tried.
And what did they say?
There was no response from Eskom.
And then what is curious, you say that ultimately the two invoices referred to in paragraph 47 were paid by Eskom, but under the new ownership regime of the mine being the proprietary interests of Tegeta and Oak Bay, correct?
Correct.
Why would Eskom pay money to an entity which did not supply coal to it, and not to Optimum Coal, which was then under business rescue and not controlled by Tegeta and or Oak Bay?
Just to correct you, Mr. Maleka, that these payments were made in June 2016 when when Oak Bay had control.
No, I understand, but the point is different. The point is payments in June 2016
Yes.
are made in respect of coal deliveries, not by Tegeta and or Oak Bay. These are the invoices already issued.
No, so these payments were made to OCM in June 2016.
I understand this.
Not directly to Tegeta. Okay. And why they were paid a year later, I don't know.
Yes, maybe I'm
If that's
drawing too fine a distinction. But the simple point is that Oak Bay, OCM at that point in time, relied on its parent company for financial support. Correct?
are you referring to July 2015?
Yes.
Yes, correct.
Yes. And those were the shareholders who were interested in that payment because it is their asset.
Correct.
Yes. And they were not paid at that point in time.
No.
Yes. And the payment is made to the same company but under different ownership.
That's correct.
Question is why?
I can't answer that.
All
I
right.
take it that when you say you can't answer it, you mean you don't know the
I
answer.
don't know the answer, to
Yeah.
be precise.
Okay, you are not refusing to answer.
No, I'm not refusing to answer anything.
Yeah. Okay.
Chair, for me, it sounds a bit difficult, but I accept that I'm not a businessman. But if my company is under financial stress and I'm
Yeah.
using my resources to fund its operation
Yeah.
and the client doesn't pay,
Yeah.
I mean, I would certainly raise that issue seriously, even if it means that I walk to the door of the client and say,
Yes.
please pay.
Yes.
But it's something that Mr. Ephraim can help us with. We can move on. We are at paragraph 48. And you explained quite clear in that paragraph that the objective of the business rescue practitioners was to avoid liquidation, correct?
Correct.
Yes. What would have happened if liquidation had taken place? Just in brief, in terms of the interest of the parties at play, the interest of Eskom and the interest of OCM.
So, besides job losses, besides the cessation of deliveries of coal, there's numerous factors that would have occurred as a result of liquidation.
So it was in the interest of all concerned to avoid that potential consequence.
Absolutely.
Yes. Okay. And the business practitioners had that in mind when they addressed the letter of 20 August 2015. Chair, you'll find that letter at page 197.
Thank you.
It is addressed by worksmen's attorneys on behalf of the BRPs. You will see that it is addressed to two persons. Who are they?
It's addressed to Machela Koko at Eskom and Vusi Mboweni, and also a Yandan Teta.
Yes. And then it proposes a way forward in relation to how the operations of OCM could be saved by making an offer. You will see that on page 198. And unless you think otherwise, I direct your attention to paragraph 7 on page 198. Do you see that?
I do, thank you.
And it's an offer to supply coal to Eskom by way of an interim agreement at a price. Do you know what the price was? I mean, my reading of this is that what this letter was proposing was what the parties had negotiated under the fourth addendum.
I think the number would have been similar. And the reason why I say that is because it would have been based on the costs, to recover the costs of Optimum, keep the mine open, recover the costs of what it produced coal for Eskom. It's important at this stage to know that the mine was only producing coal for Eskom, so all the costs associated with the mine would have then been lumped into the cost to supply Eskom.
Yes.
It was a very easy calculation.
Yes. In fact, when you look at the middle of paragraph 7, it says the costs in the interim agreement are not materially different from the costs provided to Eskom as part of the cooperation agreement process, and have only been adjusted to take account of the different time period during which the coal is to be supplied. See that?
That is correct.
So they are repeating the historical basis of charging the price,
That is correct.
which had been previously expressed in the days of the cooperation agreement.
That is correct.
All right. I wonder whether you'll be able to explain to us what was the response of Eskom to this worksman's proposal. You can pick up an answer to that question from paragraph 50 of your statement.
Paragraph 50 comes a little bit after.
Okay.
Just give me 1 second. I can't seem to see the exact date that they responded.
Right. Can we take it from this perspective that we now know that the BRPs had suspended the supply of coal to Eskom,
Yes, that's better.
and then Eskom started to engage with them, and that's when a meeting was called
That's correct.
between them and Mr. Koko.
Okay, I've now got my thoughts back in terms of how the sequence of events. It was some years ago.
Yes.
So the business rescue practitioners were appointed on the 4th of August. There was various attempts for a meeting to reaching an agreement, and this was in 48. However, Eskom refused to meet with the BRPs. It was in the last situation, the last moment on the 20th of August, the business rescue practitioners, and they'd be better placed to describe this, but the business rescue practitioners, within their right, suspended the onerous contract of Optimum to Hendrina Power Station. And with that suspension, they indicated that they would be willing to offer an interim arrangement to supply coal at cost while a negotiation could take place for the longer term.
Yeah.
And that went on until the 3rd of September,
Yes.
where Mr. Malefi and Mr. Koko called the business rescue practitioners and myself to a meeting at Megawatt Park.
You attended that meeting.
Yes, I did.
Can you tell us what happened?
So when we arrived at Megawatt Park, we went into the meeting room, we were told that Mr. Malefi and Mr. Koko wanted to meet with me alone, which I did. And at that meeting, can I say it wasn't very pleasant, Mr. Malefi and Mr. Koko advised that we must immediately restore the supply of coal to Hendrina. I said at the time that now I'm in a position of purely as Glencoe, as the, let's say, still the management of the mine under the business rescue practitioners, and as a shareholder, as Glencoe. So I couldn't make that decision. It's always subject to the business rescue practitioners. I did, however, say that subject to Glencoe agreeing, which I would have to double check with my superiors, that then we would continue to fund the mine in order to supply Eskom, because supplying Eskom was very onerous, and for every ton you supplied, you didn't get paid. So we had to continue to fund. And that was when we undertook a commitment to continue to fund and to turn the conveyor belts back on. But that was clearly on the commitment from Mr. Molefe that they would negotiate with OCM in good faith.
You see, what I find surprising is this, that you are not the manager of the business at that point in time. And the true and legal managers of the business are shut out of the meeting. And you are asked to talk about operational matters relating to that business. And that's a funny set of circumstances.
It is strange in one sense, but in another sense, Glencoe was supplying the post-commencement funding. So Glencoe was supplying the PCF to Optimum for it to continue in the same way as it was before the business rescue proceedings. So if Glencoe did not continue that funding, business rescue would end and liquidation proceedings would commence. So speaking to Glencoe wasn't as strange as it appears.
But you undermine legal processes.
Possibly right. At that point in time, it appeared it was strange, but it allowed the business rescue practitioners allowed me to meet with Mr. Molefe and Mr. Coco alone.
Yes.
So I could only have assumed that they sanctioned it and were happy with me to do that.
Yes.
It wasn't my jurisdiction.
Yes. Well, what happened? What was the end point of that meeting?
The end point of the meeting succinctly was that Eskom agreed that they would open up negotiations with Optimum in return for restarting the supply of coal.
And did you get a sense of what will be the nature of the negotiation?
No. At that point, no. We, at that point, just wanted a foot in the door rather than sitting with the CEO of Eskom discussing the terms of a deal.
I take it that you reported to the BRPs what the outcome of the meeting
Immediately
was.
thereafter.
Yes.
And my superiors.
And you also say that you reported to Mr. Glassenberg.
That's correct.
Yes. And the BRPs took a view of what should happen in the light of the promise for negotiations. Correct?
Correct.
And you tell the story about that view from paragraph 53.
That's correct. We contacted Mr. Molefe again to advise him that we've agreed Glencoe would provide further funding for OCM. I'm reading from paragraph 53.
Yes.
And that the BRPs had agreed that OCM would recommence the supply of coal during a negotiation period. What is important is that it would be at a price of 150 Rand per tonne,
Yes.
which was the CSA price at that point. And payment needed to be made every 7 days. You would appreciate that Eskom had withheld payment previous month, so
Yes.
the business rescue practitioners, the BRP's point of view that because Eskom withheld payment, causing further hardship, it was agreed that payment would be made every 7 days.
Yes. And then what was Eskom's response?
Eskom agreed.
And then in paragraph 54, you say that Eskom did not engage in any further negotiations, despite OCM providing significant information to Eskom to demonstrate its precarious financial position. Correct?
Correct.
We'll get to paragraph 61 that you cross-reference. You begin to talk about the second Oak Bay offer, unless there is any further issue you want to raise in relation to the first offer, the introduction of the BRPs, and where matters ended after they had assumed management of OCM. I'd like to deal quickly with the second Oak Bay offer.
That's fine.
Are you happy with that?
Sure.
You set out the second offer at CE 13 chair. It is at page 207.
Thank you.
This time the offer is made by Oak Bay itself. You'll find it at 207.
Correct.
And it's around September 2015. Again, it's a non-binding offer. And the purchase price is set out in page 209, paragraph 3. It is a purchase price consideration of 1 Rand for acquisition of shares together with certain financial commitments. Do you see that?
Yes.
All right. What I see that the offer was addressed to the BRPs. Did you yourself acquire knowledge of this offer, and if so, when?
Can you ask the question again, please?
If you look at page 207, the offer
Yes.
was addressed to the BRPs
Yes.
because they were managers at the time.
Yes.
When did you get knowledge of this offer?
We would have been advised at a similar time.
More or less the similar time.
Yes.
All right. And do you know what was the response of the BRPs to this offer?
Well, yes. The BRPs wrote back asking for certain explanations and clarifications around the offer, and that's specified in CE 14 on page 212. It
Well,
was
mine
the-
is 215. I mean, do you say 212? Yeah, 212, yes.
It was a normal type of negotiation that would discuss all the different aspects that would be involved in terms of a deal of such
Yes.
nature. And I'm referring to page 213 now.
Yes.
The likes of interim period financing, post-commencement financing, long-term borrowings, environmental liability, contractor, etc., Eskom, all the other stuff that would ordinarily be required for such a transaction.
Yes. So the BRC were trying to engage in earnest with that offer.
That's correct.
And then you divert a bit from that second offer and the BRP's response by flagging an event which happens on the 22nd of September 2015. You do so in paragraph 58. And you say the following day, that is the 22nd of September 2015, President Jacob Zuma announced that he would appoint Mr. Museveni Zwanny as the Minister of Mineral Resources from 23 September 2015. Correct?
Correct.
Yeah. Is there any significance to your reference to that event?
No, I think it just follows the ordinary course in terms of the sequence of the document to indicate when Minister Swanny was appointed.
Yes. You simply record a historical fact, correct?
Correct.
Yes. And then you deal with matters relating to an engagement that the BRPs were undertaking relating to something you describe as the first long-term proposal. You do so from paragraph 59. Can I ask you just in simple, summarized format, what that proposal was all about? What did it seek to achieve?
So I think it was important to note that whilst there was an offer from Oak Bay at the time, it was first prize for the shareholders to do a deal, or for the business rescue practitioners to do a deal with Eskom directly. And that's what brought rise to the first long-term proposal. Also in line with the discussions that I had had with Mr. Molefe at the time that indicated that Eskom was willing to negotiate in good faith. And the long-term proposal is very, very similar to the fourth addendum.
Yes. Thank you. Chair, Ms. Molefe has just picked up the date relating to that meeting between then Minister Ramatlodi, Dr. Ngubane, and Mr. Molefe. And
Yes.
she says that it was around September 2015 when that meeting took place.
Okay. Thank you.
Thank
And can you remember where we were when, what months we were when we were talking about the meetings that the witness was having with Ms. Molefe, I think May and June.
It was
2015.
the first one was in May, the second
Yeah.
was in June, and there was another one in July.
Yes,
Yes.
both in the same year as
This one,
date. Yeah.
yes.
Okay, thank you. Thank you. That's very helpful.
I mean, you confirmed that you had by now, by September, had a sum total of 3 separate meetings with Mr. Molefe.
That is correct.
Yes. And you said that that proposal of the BRPs was submitted to Mr. Koko and to Mr. Molefe. Am I reading the contents of your affidavit correctly?
I'm just double checking.
I'm at paragraph 59.
I'm just double
We will deal with this issue in detail when the BRPs
Yes, yes.
testify. I just want you to summarize for us your understanding that there was a further engagement that took place between the BRPs and Eskom.
No, that is correct.
Yes.
A letter was sent on looks like the 17th of September, and it was a proposal from Optimum Coal Mine in Business Rescue, a settlement proposal. It was attention Mr. Brian Molefe, Mr. Machela Koko, and Mr. Rishabhan Mudli of Cliff Decker Hofmeyer.
Yes. And then there was a response to it.
And there is a long letter, and it again deals with all the issues and background of Optimum, the history, the penalties, the extension of the contract. It's almost identical to the fourth addendum. It has a few differentiations, but what was important from our perspective is that we had another objective view from the business rescue practitioners of what we were previously saying made sense in terms of the survival of the mine.
Yes. There is a response to that proposal. It comes from Cliff Decker. It is on page 228. The sum total of that response is that Eskom had considered that proposal and it did not accept it. And Eskom was insisting on payment of penalties which had to be made in full, and that was not negotiable.
That's correct.
And then there's an issue which is raised by Cliff Decker around asset stripping. You'll see that on page 228, paragraph 3.
Correct.
And of course, Worksman's respond to it on page 230.
Correct.
And you are aware of that response?
Yes, if I may, I think it's worthwhile to read Worksman's response.
Yes. Chair is at page 230.
Worksman's
Yes, I've found it. Thank you.
Worksman's letter is to Cliff Decker Hofmeyer, attention Mr. Rishabhan Mudli. And there are 2 paragraphs I'd like to read. Clauses. There's clause 2 and clause 3. Clause 2. We are disappointed that you have made no attempt to engage with the substance of our proposal or to make any counter proposal. Our clients are considering how to proceed and we will revert in due course. This is, of course, on behalf of the business rescue practitioners.
Yes.
And then in point 3, our clients categorically reject the allegation that any assets are being stripped at the Optimum mine. No assets have been removed from the Optimum mine except for certain arm's length disposals of minor assets that were surplus to requirements, which have been approved by the joint business rescue practitioners in accordance with section 134 of the Companies Act and the secured creditor who has taken possession of all of OCM's movable assets.
Yes. It's a serious allegation to make about and concerning the business rescue practitioners.
Correct.
Yes. Do you know how this issue was resolved ultimately? Or was it left purely at the matter of making allegations and repudiation of those allegations on behalf of the business rescue practitioners?
From my recollection, this never came up again.
All right. Then the next chapter of your statement deals with the offer by Pembani.
Yes.
We now know who Pembani is.
Yes,
It is the minority shareholder in OCM.
that's correct.
All right. You deal with that issue from paragraph 62. You can summarize it fairly quickly because we know that no headway was made in relation to that offer for one simple reason. And you know what was the reason why Pembani could not progress negotiation relating to its offer?
Yes, I do.
Yes, tell us.
That was Pembani thought, in their opinion, that they would be able to in some way negotiate or renegotiate the CSA in terms of, in some way, that mirrored the fourth addendum.
They thought that they would achieve what you failed to achieve.
You never know.
Okay. And did they succeed?
No, they didn't.
Why not? To the
can't-
best of your knowledge.
To the best of my knowledge, I do not know why.
But you say in your statement that Eskom refused to negotiate the CSA as far as Pembani told you.
They gave Pembani the same answer that they gave the business rescue practitioners and the same answer that they gave Glencoe.
All right. And then Pembani finally told you where it stands in relation to that offer by writing a letter to you, and the letter was received by the BRPs on the 11th of February 2016,
Many months later, yes.
many months later. Chair, is at page 252. If
252.
yes.
Thank you.
Of course, by this time, when Pembani writes this letter, there had been some significant progress relating to the negotiations between Oak Bay and Otageta with Optimum coal mine through the BRPs, correct?
Correct.
You begin to talk about the progress relating to those negotiations from paragraph 66 of your statement. And you refer to a meeting which was held on the 20th of October 2015, which involved representatives of different stakeholders, the BRPs, Glencoe, and representatives of Oak Bay.
Correct.
You give us the names there.
Correct.
You were present at that meeting,
I was.
and can you sum up the discussions which took place there and the upshot of those discussions?
The discussions were around the sale of shares of Optimum coal mine only and did not include any of the other assets that were owned by Optimum Coal Holdings. It was a relatively brief discussion, and it was very much in line with offer number 2 that we'd received from Oak Bay.
Where did the discussion take place?
In Saxonwold, at the home of the Guptas.
Do you know why it was held there?
No. They requested it, and we agreed.
All right. In paragraph 68, you record a position taken by the BRPs in relation to the discussion relating to Oak Bay's offer. And you set out the parameters of the transaction, correct?
Correct.
Can you summarize the parameters of the transaction for us? Because it seems to me that it is no longer around the mine only, but also of other assets that were involved in the course of the transactional parameters of the discussion?
No, at that point in time, it was still only about OCM. And we specifically indicated that OCH's interest in the Richards Bay Coal Terminal the sale would not include that asset.
Oh, I see. So at that time, you took the view that the R1 offer related to the mine only, correct?
Correct.
Thank you for that. And then the BRP imposed some date by which Oak Bay had to complete a DD, correct?
That is correct.
And that was the 30th of November 2015.
That is correct.
Okay. And the DD was done. Do you know when it was completed?
No, but it would have been before the 30th of November.
Whenever it was, there was some progress relating to the negotiations, because you say in paragraph 71 that on November 12, 2015, Oak Bay and OCH and OCM concluded a non-binding term sheet.
That is correct.
Yes. Chair, you'll find it on page 253. I'm not going to waste time on it unless Mr. Ephraim would want to raise several issues around it.
Thank you.
I'm interested in the next paragraph that follows. You say someone out of the blue contacted you about the proposed acquisition of OCM. Who was that?
That was Mr. Joel Rapella.
Who is he?
He was the Deputy Director General of the DMR.
Did you know him before he contacted you?
Yes, I did.
And why did he contact you in relation to this transaction?
He contacted us to indicate that he is aware of the transaction, to reiterate that Optimum was very high profile in terms of the media, and
Yes.
of course the DMR was aware of it.
DMR again being the Department of Mineral Resources.
That's correct. And he indicated to me that a sale of OCM, in other words, the mine only, would not be sufficient, and that all the assets of OCH would need to be included in a sale of any sale process.
He was a third party to the negotiations.
That's correct.
Do you know where he got information around the negotiations?
I'm not aware.
Do you know why he would be interested in expanding the asset base of the transaction?
He did not elaborate, besides the fact that, in his view, it made more sense. I didn't get the impression at that point that he understood the intricacies of the deal.
Okay. Chair, can I move on?
Yes, you may move on.
Thank you. And then you refer to a meeting that was called on the 24th of November 2015.
That is correct.
Who called that meeting? You deal with it at paragraph 73.
Yes, I see that. I'm not sure who it would have been. No, sorry, Eskom called the meeting.
Eskom called the
Eskom
meeting.
called the meeting.
Did you attend that meeting?
No,
You did not. Do you know who attended it?
I do.
Okay, who did?
The meeting was attended by Mr. Blankfield on behalf of Glencoe,
Yes.
the BRPs. Oak Bay, he was represented by Mr. Hawa, Mr. Chawla, and Mrs. Ragavan. And Eskom was represented by Mr. Coco, Suzanne Daniels, Edwin Mabalani, and Ayanda Nteta.
Yes. And you refer to a copy of the minutes that you identify in CE23. And I've looked at the minutes, Chair, they are to be found at page 259 All I'd like
you.
you to confirm in that regard is that Eskom expressed a view about what it expected OCM to do, notwithstanding the fact that there were negotiations, and notwithstanding the fact that it called for that meeting to provide an update to it of the negotiations.
That is correct.
Yes. What was the bottom line of Eskom?
It's clearly articulated in paragraph 74 on page 19, if I may.
Yes.
Mr. Coco further stated that Eskom would not provide consent to any transaction with Oak Bay unless the transaction extended beyond OCM to include all assets of the OCH group, including OCH interest in the Richards Bay Coal Terminal and Koenfontein.
You have already told us that this is not the first time that a third party outside the negotiating party raises the question of expanding the assets relating to the transaction. You have indicated that Mr. Rapella raised the issue, and you were quite surprised why he would raise the issue, and you realized that he did not understand the complexity of the transaction, correct?
That is correct.
That issue is, again, raised by a third party who was not part and parcel of the negotiations, and that is Mr. Coco.
That is correct.
Okay. Why would he raise that issue? Do you know?
Yes. At the time, we considered, because there was a guarantee between OCH and OCM in lieu of OCM's requirements to perform the contract of the CSA, that in the event that OCM did not perform that contract, Eskom would have a right to claim against that guarantee towards OCH. And OCH had other assets, which we've discussed, the two other subsidiaries and various other smaller ones. So it was with that in mind, we assumed at the time that that was the purpose of why they wanted to join the other assets into the sale process.
So the idea was to protect the interests of Eskom.
That's correct.
Yes. The guarantee and the protection of Eskom interests would work to the extent that the guarantee was alive, correct?
Correct.
What happens the moment OCM is now owned by a third party? Let's assume for now that OCM is now owned by Tegeta and Oak Bay. What would happen to protect the interests of Eskom in that regard?
Eskom would need to somehow satisfy themselves that the guarantee has some value. So there would have to be either other assets or cash collateralized or something to that effect, because there was a guarantee. That guarantee was in place in the original CSA. So if one bought OCM on its own, then something would need to be done in order to protect OCM, to protect Eskom under that guarantee.
So you'd expect to be the same mirror of the same protection.
That's where we thought that came from. That's why we indicated that it has some merit.
Yes.
Did the two meetings, namely the one with Mr. Pella and the one with Eskom, both of which were in November, did the two meetings take place within days of each other? Or are you not able to remember?
To be honest, I could not recall the exact date that the
Yes.
meeting took place with Mr. Rapella, besides the fact that it took place during November.
Yes. Okay, all right. Thank you.
Thank you, Chair. You then reflect on the attitude adopted by Mr. Coco in paragraph 74 of your statement about how Eskom may consider consenting to the transaction involving the sale of OCM. Can I ask you just in brief to deal with what were his requirements at that point in time?
I think it's reflected in the minutes,
Yes.
which is on page 259.
Yes. But to summarize the minutes in
Yes, just to
paragraph
summarize the
74.
minutes was simply put that Eskom was not willing to renegotiate the contract in any way, and that, again, that the other assets of OCH needed to be included in the sale process.
Yeah, any future transaction which Eskom would be willing to bless must involve also the sale of Glencoe's interest in the coal terminal and also the Goerfontein mine.
To correct you, OCH's interests.
Thank you very much. OCH's interest in the Richards Bay coal terminal and Goerfontein mine.
That's correct.
Yes. And what is interesting is a matter that we have dealt with, but you say in the interest of fairness to Mr. Koko. You say, and I quote, Mr. Koko's position had some merit, but I noted it was the same message that I had received from the DMR earlier that month, correct?
That is correct.
Yes. Chair, I'm going to move to a different topic, and it involves the meeting between Mr. Glassenberg and Minister Swanee at the time.
Yes, before that, you say Mr. Koko's position had merit. Is that because of the financial position in which OCM would be if Glencoe withdrew its financial support? Is that the reason why you say what he said?
To be a little bit more specific,
yes,
there was a guarantee between OCM and OCH.
Yes.
And
yes.
OCH had other assets.
Okay, yes.
So in the event
yes.
of there being a problem at OCM level,
yeah.
they would be entitled to claim against other assets
yes.
from OCH.
Okay.
It was not a Glencoe guarantee.
Okay.
This cross guarantee, this guarantee was in place from the original CSA dated 1993.
Yes. So the principle is correct. It's just the identity of who provided the guarantee, OCH instead of Glencoe.
That's correct.
Yeah. Okay.
It's security, I mean.
That's correct.
Yes. If you're happy, we can move to the next topic, which you begin to deal with from paragraph 75. And it's a matter that had received serious attention from the Public Protector Chair, as you remember.
Yes. Yes.
Mr. Ephraim, can I ask you to deal with that issue?
So the initial contact was made by Minister Zwanny's office directly to Mr. Glazenberg's office in Zurich, Switzerland, to set up a meeting for the 1st of December 2015 between the Minister and Mr. Glazenberg. At that stage, there was no indication of what the Minister wanted to discuss with Mr. Glazenberg.
Yes. Your understanding is that it is Minister Swanee who initiated the meeting?
That is correct.
Okay. And you make it quite clear in paragraph 16 that the meeting, paragraph 76, I'm sorry, that the meeting was scheduled to take place in Switzerland on the 1st of December 2015.
That is correct.
I am happy to follow the sequence of the meeting and skip paragraph 77, which I can come back to, or we can deal with the sequence of events as we describe from paragraph 17, and later we will get back to the meeting.
But before that, let's go back to your answer to the question that whether it's your understanding that it was Minister Swanee who initiated that meeting. How is your level of confidence that that is actually the position?
This is what I'm told is 100% accurate.
Okay, thank you.
All right, let's follow the sequence of your statement. You then introduce a third offer
Yes,
from Oak Bay.
that is correct.
And you say that it was for the amount of 1 billion rand. Correct?
That is correct.
Do you remember what assets were covered by that purchase price?
It was all the assets of OCH, which included the other subsidiaries, specifically OCT, which was the Richards Bay allocation, Richards Bay coal terminal shares, and Koenfontein.
And you say that Glencoe considered that offer but was not prepared to accept it.
That's correct.
Yes. I will not ask you why not. Then you referred to a meeting which was held on the 26th of November 2015. You do so in paragraph 80 on page 21. Do you see that?
Yes, I do.
You were present at that meeting.
Yes,
Who else was present?
Mr. AJ Gupta.
And what did you tell him at that meeting?
I told him that the offer of 1 billion rand for all the assets of OCH was declined.
And at that stage, OCM was still in business rescue.
That's correct.
Yes. And there was, again, the threat or the potential for liquidation.
That's correct.
Yes. And then,
Was the offer 1 million or 1 billion? I thought you said 1 million.
1
billion.
1 billion.
Yes. Okay.
we go to a different topic, and it's a matter that was considered by the Portfolio Committee and also the Public Protector, relating to the so-called Section 54 notices. It's Section 54 of the Mine Health and Safety Act 29 of 1996, Chair. I'm sure you've had an occasion to deal with these sorts of notices before, correct?
Yes.
Yes. And they are issued by inspectors of mine whenever they come to the conclusion that there were safety issues relating to the mines.
It's the extreme case. The
Yes.
Section 54 is the most extreme section in terms of safety.
Yes. You identify 4 Section 54 notices which were issued sometime in November, and you refer them from page 262. Chair, we are investigating this issue, and I've been asked to assure you that once the results of investigations have been made, evidence will be presented before you about this.
Okay.
I know that the investigators have arranged for consultation with the inspectors who have issued these notices.
Yes.
But for the purposes of your evidence, and Ms.
Yes.
Hofmeyer asked me to ask you this,
Yes.
why would the inspector issue these notices to Glencoe mines at that point in time? Did you have any history of non-compliance at those mines?
Section 54s were not a regular occurrence, but they do happen in the industry. So Section 54 is aimed at stopping an entire mine in the event that the DMR or the inspector identifies an infringement that could affect people's lives. To the extent that it affects people's lives, the DMR has the right to issue a Section 54, and the mine must down tools and all the workers should go home.
You say Section 54 notices are the extreme notices that are used, by which I take it you mean it must be a very dangerous safety situation that gives rise to those types of notices being issued.
That's correct.
Are there other notices that are issued maybe in terms of some other section where it's not an extreme situation in terms of danger or safety?
Yes.
That are issued, and if so, what are they called?
So the one I do know is the Section 55.
Yes.
Which specifically closes down a section of the mine
Yes.
that has the infringement.
Yes.
Section 54 shuts the entire mine.
Yes, yes.
Section 55 impacts only on the area where the infringement occurs.
Okay.
And then there are other sections
Yeah.
which don't shut the mine down at all,
Yes.
but there is an infringement and that they need to be rectified as soon as possible.
Okay.
There is a mechanism
Okay.
that deals with it.
So as you understand the position, there are different categories of notices that are issued, and they are issued according to the seriousness or otherwise of the infringement.
That is correct.
Okay.
Yeah. All right. In paragraph 85, you say, and let me read this out together with you. You say, it is not uncommon for multiple Section 54 notices to be issued to a single operator so close in time, and they were accordingly of a serious concern to Glencoe. And you say this in the context of paragraph 84, where you said that these notices were unduly harsh and disproportionate to the contravention identified in the actual text of the notices. Correct?
Correct.
Yes. And I mean, I've looked at them and you have looked at them. They relate to the operation of a truck, which is unrelated to the operation of the underground mining activities. And yet they call for the shutdown of the entire mine.
That's correct. They were frivolous, Mr. Deputy Chair, Deputy Chief Justice.
Had you ever been served with Section 54 notices prior to this occasion as a mine?
Yes, we had.
How often in the 20 years or so that you have been there, maybe a little more than 20 years? To the extent that you, whatever positions you might have held, might have exposed you to that knowledge or might not have exposed, but to your knowledge.
They were quite rare. They did
Yes.
occur,
Yes.
and in some instances for good reason.
Okay. Okay.
So it was it's a very good tool that
Yes.
is used by the DMR to ensure compliance by the mines.
Yes.
Safety of life is of paramount importance. So
Yes.
there
Yeah.
needs to be a mechanism to
Yes.
manage it.
Yeah.
But they are not common,
Yes.
and when a Section 54 happens,
Yeah.
it's extremely concerning for the mine and management of the mine, and needs to be rectified immediately.
Yes. So as you understand the position, they are reserved for extreme cases of safety legislation infringement.
That's correct.
Okay.
And you say, what was unusual about some of these notices is that they were issued over the weekend.
It's very uncommon that the inspectors work over a weekend to issue a Section 54.
Did you raise your concerns about these notices with anyone at the DMR?
Yes, we would have raised it not formally, but informally. We would try to, the relationship between the DMR and the mines is of paramount importance. So we would speak to the DMR all the time with respect to inspections and infringements. So we would immediately have spoken to the DMR with respect to these Section 54s.
And then you say that the surmise you make is that these notices were issued for a specific purpose. And let me leave it to you to describe for us what you think the purpose was.
I think it's important that we reflect at the time.
Yes.
Of course, again, I'm going to reiterate, with the benefit of hindsight, it's always more simple. But at the time, we thought that it was a clear warning shot to Glencoe from the DMR regarding a potential liquidation of OCM. And to our mind, that implied that we would need to support an offer for the sale of Optimum in order to ensure its survival.
Chair, I see that it's already 4 o'clock. I have arranged with Mr. Ephraim that we will continue beyond the normal time of adjournment, and I'm quite comfortable that I will finish well within 30 minutes. I wonder whether we should not take a short break for 5 minutes.
Let us. Well, I'm happy to continue if we can at least finish by no later than 4:30, so I can meet my other commitment in chambers at 5 o'clock. Yeah.
Mr.
But I may not have heard, did you ask that we proceed immediately, or did you speak about...
No, I thought there was time for a short break, but if there's no time, we should...
No. You said you are confident you will finish well within 30 minutes, so if we take a 5 minutes break, it won't...
Yeah, we should be finished by 16:35, somewhere there.
Yeah, okay.
But
are you adding the 5 minutes for the break?
For the break, yes. I don't want you to hold me back about my...
No, let's take the 5 minutes break.
Yes.
You'll probably need...
I think I can see that Mr. Ephraim is just getting tired as I am, but maybe...
Yes. Okay, we'll take a 5 minutes break. We adjourn. We'll be back at 25 past.
All right.
10 past.
Mr. Ephraim?
Yes, Mr.
Thank you, Chair. In order to answer the question that the Chair has put to you about proportionality of the infringement identified in the notices, can I ask you to go back to page 21, paragraph 83?
Sure.
And identify the infringement which the inspectors alleged. Can you deal with them quite quickly from paragraph 83.1?
Yes. So we've picked out from the different mines the reasons for the Section 54s that were issued against the mines. And these, I'm reading from 83 on page 21. The reasons provided for the suspensions, as set out in the Section 54 notices, included the following representative examples. An excavator for Excavo mining mini truck not having a license and checklist with him while operating. 83.2, safety belt was not used by the Excavo mining truck operator. 83.3, operator's seat was not adjusted and there were engine oil leaks. 83.4, 4 dump trucks found without first aid kits. 83.5, wheel loader 2 with a cracked windscreen since 21 November 2015.
Yes, I don't want to belabor the point. How would that affect the operation of the mines?
They couldn't.
Okay.
So, is my understanding correct that in respect of one Section 54 notice, what was being directed is that a particular mine be closed, the operations be closed because the operator's seat was not adjusted and there were engine oil leaks. Would that be one incident that was considered by the relevant official at DMR to be sufficient for purpose of closing the whole operation of a mine, or that would be one of a number of alleged infringements?
These were examples of one of a number of infringements in each of the 54s, but they were all equally as frivolous as these ones that we picked out in terms of examples.
Is a Section 54 notice, when it is issued, does it necessarily mean the closing down of the operations of the mine?
Immediately.
Immediately.
Yes.
Immediately.
Everything.
Every single operator, every single person needs to down tools.
So in other words, irrespective of whether there were other alleged infringements, if here we may have a situation where there was a Section 54 notice issued on the basis of the allegation that the operator's seat was not adjusted and there were engine oil leaks. For that, a Section 54 notice was issued. Is my understanding correct?
For the entire mine.
For the entire mine to be closed down just because of that?
The entire mine needs to stop.
E146 operator's seat was not adjusted and there were engine oil leaks. D, ADT 141 and ADT 140 were leaking oil and the hooter were not working and they were not recorded as such on the checklist. E, HCL blah 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 and tractor operator were not having mine license and did not complete the checklist. So in regard to that section 154 notice, those were the reasons given.
That's correct.
Why the whole operation of the mine had to be closed.
That is correct.
Yes. Production comes to a halt. You have to lift people out of the shaft and bring them on the surface.
That is correct.
Yes. Well, you then explain in paragraph 88 that the section 54 notices were ultimately lifted on the 30th of November and the 9th of December 2015 at a significant cost to the business. Can I confirm with you that those relate to the costs of the affected mine and they don't relate to Optimum coal mine?
That's correct.
Yes. And then you talk about a commercial decision taken by Glencoe to continue to fund the operations of Optimum coal mine under business rescue.
Yes, I think this is an important point.
Yes, I'd like you to deal with it if you can.
So on the 29th of November, we held a conference call. with, when I say we, it was myself, Piers Marsden, the business rescue practitioner, Mr. Blankfield, met with Mr. Coco at Eskom's offices to advise them of our decision that had been made on the, I think it was the day before.
And the telephone conference.
Sorry, the 29th of November.
Yes.
2 days before.
You had already conveyed your
We
decision.
conveyed
to
our
reject
decision
the
to
offer.
Mr. Coco on the 1st of December, and he was pleased with that, the decision that Glencoe was going to take the company out of business rescue.
Yes.
So at the same time of that Esco meeting, a meeting was held, I'm now reading on page 24, paragraph 94. At or about the same time as the Esco meeting, the meeting between Mr. Swanny and Mr. Glazenberg took place at the Dolder Hotel in Zurich. I understand that the meeting was also attended by Mr. Salim Issa. Mr. Issa. Mr. Glazenberg had not met Mr. Issa before and did not know who he was. When he asked who Mr. Issa was, he was told that he was an advisor to the minister, Swanee. I understand that Mr. Glazenberg asked Minister Swanny about the Section 54 notices, but that Minister Swanny did not engage with him on this issue, instead noting that he wished to use the meeting to meeting, as I've mentioned. It was opened by Minister Swanny, who noted the importance of securing employment at the mine, expressed concern that the mine should not enter a liquidation process, and stated that the best outcome would be for Glencoe and Oak Bay to reach a deal. 98.2, Mr. Zurich then left the meeting, following which Mr. T. Gupta, Mr. Glazier discussed the third Oak Bay offer. After negotiation of the terms of a potential transaction, a purchase price of 2.15 billion was agreed, which was over double the amount of the third Oak Bay offer.
Can I just ask you to give us a snapshot of the negotiations? You were present when the to and froing took place.
I was. It was quite simple at that time in terms of where we were as Glencoe. We had done numerous financial evaluations as to the cash flows, the costs, the net present value of the mine, and we came to a point where let's say the lesser of two evils was to sell it or to keep it at a certain price. So in other words, we came to a price of 2.15 billion, which would have been the same price or the same financial implication to us to either keep it or to sell it. So then the question would arise, why would you sell it? And the only reason that we agreed to sell it was that there were a number of assumptions that we had made in establishing the NPV to get to 2.15 billion, which would still have to occur. And there was substantial risk associated with that. And that's why the agreement was reached at 2.5.
In 98.3.
Yes.
And you raise another issue relating to the sale. And I'd like you to deal with it from the third sentence of paragraph 98.3. If it's comfortable to you, you can read it.
Is it from Mr. T.
Yes.
Gupta?
Yes.
Mr. T. Gupta also spoke about the rehabilitation trust funds. At that stage, the rehabilitation trust funds for OCM were invested in equity instruments. This was the Glencoe's group policy at the time. And short-term volatility. Mr. Gupta indicated that the purchasing entity would not assume the volatility risk, and therefore he requested 600 million and said that Oak Bay would get Eskom to pay the first 600 million of coal sales to Glencoe. Glencoe declined this request. At a meeting on 11 April 2016, Mr. Marsden, one of the BRPs, was advised by Mr. Hauer that Tegeta was 600 million short, and Mr. Hauer requested that Mr. Marsden approach the consortium of banks, requesting a bridging loan in an amount of 600 million in order to facilitate the shortfall on the purchase price. Mr. Marsden arranged a meeting with a consortium of banks, whereafter Mr. Marsden advised Mr. Howard that the consortium of banks was, excuse me. One second. Consortium of banks was not prepared to finance the shortfall of the purchase price.
This must have come at that point in time as surprising news for you, because through the various offers that we have seen, you were told that the entity, the acquiring entity, had enough cash equivalent and funding from all of its banks.
That is correct.
Now you're told for the first time here, closer to the date for the fulfillment of the C piece of the transaction, that the acquiring entity is short of 600 million rand.
It was a surprise.
It seems to me that what you had been told or what was represented to you was not, as a matter of fact, true in the light of these developments.
That is correct.
I would like you to sum up. But before you do so, can I ask you to confirm, and I should have said so in the beginning, that you stand by the correctness of the statement which we have now conversed?
I do.
Yes. Chair, I have come to the conclusion of my questions. The one or two broad propositions I'd like to put to Mr. Ephraim, but I think in fairness, we would ask him to make his concluding remarks before I put those two broad propositions.
Well, I thought you would put those first, and then when you are done, he can do his concluding remarks if he has any.
Thank you. From what you have told us, it is quite clear that the Optimum coal transaction reflected an amount of pressure points brought to bear on Glencoe and or Optimum coal holdings. We have reflected on them. The first was the question of penalties. We have dealt with them. The second was the question of Section 24 notices. We have dealt with them. The third was the question of an attempt to enlarge the assets that had to become part and parcel of the transactions. The last was a refusal by Eskom to deal with anyone other than Tegeta and or. Those pressure points into taking all of
I think they will attend to whatever's happening at the end. Let's proceed and conclude.
What is your view of the role played by the non-parties to this transaction? And by that I mean people on your version.
We were suspicious of them at the time. Of course, with the benefit of hindsight, and once we'd read the Public Protector's report, it was quite easy at that point to join the dots. We were shocked by what came out subsequently in the Public Protector's report.
The last issue that I'd like you to comment on, unless the chair has.
Well, I don't know whether you want to leave it at that, but it may be that he might have a view as of now based on having read the public protector's report and having looked at whatever he looked at in preparation for giving evidence and what he knows now.
Yes.
So he might be able to answer your question based on that, or he might not, depending. So maybe you might wish to let him get that chance.
Yes. Chair, let me see whether I formulate correctly.
Yes.
From what you now know, given the public revelations, given the various reports reflecting on different investigations, including the public protector, what is your view of things?
I think it's unfair for me to speculate here.
You must not speculate.
I don't think it's my job to do that.
No, you mustn't
It's
speculate.
my job to give you objective answers.
You mustn't
prefer
speculate.
to leave it like that.
And if you feel that you can't offer anything, it's legitimate.
Chair, those would be my last questions to Mr. Ephraim.
Okay, thank you very much. Thank you very much, Mr. Ephraim. You are released. Should a need arise for the commission to ask you to come back, you will be approached through your lawyers, and then you could come back. But for now, you are excused.
Thank you.
Chair, we have now received copies of Addendum 1 to Addendum 3.
Yes.
We will process them through the pagination processes of the Commission.
Yes.
And at the right time, make them available to you.
Okay.
I have had a discussion with the lawyers of Mr. Ephraim on that issue, and they're quite satisfied, as I am, that there's no need for him to deal with them.
Okay, no, that's fine. That's fine.
Lastly, Chair, it's just a matter of setting the program for tomorrow.
Yes.
I believe that Mr. Manuel will be coming tomorrow to testify.
Yes. And as I understand...
and also General Nyanda will be
Nyanda.
coming to share their experience with you.
Yes.
And our
yes.
colleague, Ms. Kabashe, and here other team members will present that evidence to you.
Yes. looking at their statements, their evidence should take a very short time. Is there a plan in place to fill up whatever time will be left after the two have finished, or is that something that your colleagues would know and you don't know?
I will ask them to get in touch with your registrar and convey to you. But Chair, I was told that Mr. Manuel's evidence might be longer because he might want to share with you matters that.
Oh, okay,
really,
okay. No, that's fine.
Yes.
Okay, you are done.
Yeah, I'm done, Chair.
You are done.
Yes.
Okay, we'll then adjourn until tomorrow at 10 o'clock. The commission adjourns.
Thank you.